So we've been learning from the speakers about the AFCFTA, and this morning we started. My colleague introduced the protocol on trading goods and the schedule of concessions. So my task now is to address one of the issues that she mentioned in relation to rules of origin. I am going to be addressing the question of origin and the rules that are attached to origin, because origin is not necessarily it's not a simple issue when it comes to trading goods. So there is a need to identify the originating product in one of the members of a trade agreement. So my task is to talk you through how it is defined, how it is framed under the AFCFTA. So before getting there, let's contextualize the topic. So, as you learned from my colleague this morning, and since yesterday, the AFCFTA, which was concluded in 2018, entered into force in 2009. So, the AFCFTA, which was concluded in 2018, entered into force in 2019, was supposed, when the agreements enter into force, the presumption is that state trade is going to start under the agreement. However, before trade can start, member needs to know on what conditions goods are admitted from one border to another. So for countries to trade or for goods to be shipped and across the borders, there needs to be conditions of admission of these products, because not all goods can meet the requirements of origin or can be traded under the liberalized market. And countries exchange concessions in this regard. They tell to one another, what are the rates that they are going to apply on specific products. And this is what has been discussed this morning by Mrs. Ndlovu. So, one country will identify the products, and they will state the rates that they will apply on these products. This is what is now consigned and recorded in that country's schedule of concessions. So, and it indicates that if you are going to be trading or sending these products, this is the rate you're going to pay. But how do they identify the country of origin of that product? So 2021, start of trading under the AFCFTA. So what were they trading? Well, we were told that on the 5th of January 2021, there was the first shipment of goods from Ghana to South Africa, a containers containing cosmetics and alcoholic beverages. But they were originating in Ghana, right? So how did South Africa know that the goods were actually originated in Ghana is one of the questions we are about to address this morning or this afternoon. Sorry about the technological challenges. We live in a world of technological disruption, so this is an indication, or at least a living example of that. So I was saying that the 5th of January 2021, the first consignment of goods were shipped from Ghana to South Africa, and it contained cosmetics and alcoholic beverages, or beverages. I don't know whether alcoholic or not. And in 2022, the Guided Trade Initiative was launched, and asking countries that have concluded their liberalization and certified their schedule on specific products to trade under the goods that have been liberalized. So actually, these are a subset of countries that have actually submitted their binding or their schedule of concessions, and these have been certified and agreed upon. So trade can now be undertaken under these commitments. So they specify the rates applied to specific products, and if you are interested in trading in these specific products, you will know the rates that apply to these specific products. You can be able to ship your goods, take into account the rates that apply to the designated product. However, trading can only occur on originating products because the agreement has been agreed or has been signed to benefit producers and products from members of state parties, not anyone else. So how do we determine that these goods actually originate from these countries and are not the Chinese product somebody mentioned in the morning? So let's start with the conceptual issues. What are rules of origin in international trade, broadly speaking? So these are administrative rules which are meant to determine the criteria used to determine the origin and status of products that are traded across borders. So these are procedures and rules that are meant to determine how products qualify as originating product. So this is very important because, well, when countries are parties to a trade agreement, they actually have decided to, or they have promised something in return of concessions. So the intention is to say, if I'm going to be granting market access to foreign products, that I need something in return. And people who are not parties to this agreement cannot benefit from something they did not take part to. So the origin is important to exclude these goods from countries that are not parties to this agreement. Under the rule of WTO, for instance, members are bound to exchange the most favored nation to the members of WTO. And this includes any advantage which is granted to a third country's product, not parties, from a country which are not party to the WTO. So if you, as a member, decide to extend any preferential treatment to a product from a country that is not party to the WTO, if it's a preferential or a preference which is not accorded to members of the WTO, you are obliged by the MFN to give them the same treatment which you gave to any country's product. So this is the case also in the AFCFTA. The MFN also applies in the AFCFTA. However, the origin comes into play here because why you will think that goods are all manufactured or shipped from one country, or that there is a presumption that if a goods is shipped from a country, then that it originates from that country. This is not true. So we need to be aware that in the international trade arena we are actually living in, goods can be manufactured using inputs from several jurisdictions. So it's important to decipher and extract from this processing which one qualifies the goods as originating goods from the countries where the transformation actually took place. So the rules are there to identify that and make that happen. Also, origin is important because if you suspect that there is dumping, for instance, that's occurring, well, you need to identify where that dumping is coming from. And for you to be able to apply your trade remedies on that, such as anti-dumping duties, for instance, you need to identify that the goods are originating from specific countries, that the goods originate, especially from these countries. And in our case, to apply preferential tariff rate, because if the goods do not originate from a member of a free trade area, that good will attract the MFN tariff that applies to the whole world. So this is also important to identify which goods can benefit from zero tariff or, depending on what is your rate, the liberalized rate, so to speak. So international trade, there are two main types of origin. The first one is what I just mentioned, or I mentioned earlier, is the non-preferential rules of origin, which apply at the international level. And you have preferential rules of origin, which apply in regional trade agreements, which is of our concern this morning. Because if goods do not originate from a member of the regional trade agreement or preferential trade agreement, then that good will attract the MFN rate. which is the MFRN, which is the rate that you apply to all other products by virtue of your WTO or not rules. So, why does it matter? So, the origin is not necessarily the country of manufacturing or the country of shipping of the product. Okay, we will see to what extent what is needed for a country, for a good to be conferred originating status. However, one of the definition is that it's economic nationality of the product, which is actually called origin of the good. So, what does it matter? The presumption is that if a good is wholly obtained from one jurisdiction, then of course that good originate in that country. I may be needing some AC here. If a product is wholly obtained in one jurisdiction, in a single country, using components that have been sourced in that jurisdiction, then there is a presumption that goods originate from that country. However, when there are components used, sourced from several jurisdictions, that's where complications actually arise, and there is a need to clarify to what extent and what are the percentage that are needed for local content percentage or the type of processing which is needed for that goods to be conferred originating status from the countries which claim to be manufacturing that goods. So this is why rules of origin are very important to assign origin to a product. So like I said earlier, it's not necessarily a country of export or country of shipment, because a goods can transit through several borders without necessarily being made there, okay? So this happens a lot. Transshipment happens a lot in international trade, where a goods can come from let's say from one country and use another border, let's say a country that without without any coastal ports for international trade. So if a landlocked country, for instance, you may use another countries to import. That doesn't mean that the transit through the transiting country will confer originating status to the transit country. So this is very important for us to identify where the goods actually originated. So if a country if a good may be exported from the country where it was manufactured, where all the inputs were obtained to conceive the final product, well, the presumption which we mentioned earlier is that the country of export is also the country of origin. However, this is not always the case when there are many other issues involved. So a good may originate in one country and be exported from another country that is manufactured, that has been taken place in country X, but inputs and components have been obtained from countries A, B, and C. So when this happens, you have to determine to what extent the last country where the goods were exported from, what are the work that underwent, the transformation that were taking place in this specific country. So it's very important. It's not very easy in this case to determine whether or not the shipping or the country of shipment is actually the country of origin. This is not clear-cut. So we have to identify what has been put into the manufacturing of that product for it to be conferred originating status. So this is very important. This, like I said, these are simply clarification of conceptual issues of rules of origin. So again, a summary for what I just said is that a country of export is the country it's the country the goods have arrived from, which is not necessarily the country of origin. And the country of export, like I say, is not necessarily the country of origin, and the origin depends on various factors, such as we will see the factors which actually are used to determine origin. So, under the preferential trade agreement, I will use that term instead of that in terms of regional trade agreements, which can be confusing. There are criteria to determine origin. The first rule is that your goods is wholly obtained. Wholly obtained is the first criteria. If the good is wholly obtained, that is a good that has been produced entirely from one jurisdiction. That is let's say an example of a cattle that was raised, slaughtered, and the meat is sold in that country. So the presumption is that it's wholly obtained and then is originating from the country where it was raised, slaughtered, and sold into meat. The same with flowers, right? When they are grown and simply cut and shipped. So usually also natural resources are usually wholly obtained in one jurisdiction if they are traded in that form. Okay, we will see that it can also be traded differently even if it's obtained from one jurisdiction. So substantial transformation. So it requires a sufficient processing of an externally sourced input. So it has undergone transformation, substantial transformation. And this can be based on several other proxies. So if you import let's say if you source your input and the result of the end product, if the end product results in the change of tariff classification of the input, then there is a presumption that the good has been transformed. For instance, if you buy chips, you import computer chips, and you end up getting a computer at the end of the day, the chip is not the computer in the tariff headings, right? So the input was under one heading, and the computer has ended up being scheduled under another heading. So this is a presumption that the good has been transformed, for instance, because of a change of tariff classification of the end product. There may be also value addition, which you will see that is in terms of percentage. It depends. It applies product by product. There may be product on which the requirement is to add simply 40%, but others, because of how easy it is to make, you may require 60% of transformation. Okay? And there may be also processes, like polishing of goods can also be used to actually obtain a goods originating in the country where the processes took place. So let's apply what we've been saying so far to the AFCFTA, which is why we are here, okay? Under the AFCFTA, they wholly obtained the substantial transformation applied to all products. However, there is also a product-specific rules, because like I said, the wholly obtained is a general rule. However, when it comes to specific products, this may apply differently. Let's say it can be in the automotive sector, it may require 60% or 40% because it's very difficult to make a car. And in the apparel sector, they may require only 40% because it's easy to make a cloth. So it depends on specific products. The legal instruments related to rules of origin. The first one, as we know, is for the agreement of the AFCFTA. And you have the protocol on trading goods. And you have Annex 2 on the protocol on trading goods. And you have appendixes to that annex. Certificate of origin, which you need to show whenever you claim origin. And there are also declaration for those who don't need to obtain a certificate. You also have a certificate, a copy of your supplier declaration, which you need to show when we talk about cumulation. We will discuss cumulation in a short while. And of course, you have product-specific rule of origin criteria, which also you need to show whenever you are trading in a specific product where there are certain requirements which you need to meet. So the protocol of trading goods is clear about its reach and about the objectives. So the preamble is very clear about what is an originating product. So it defines an originating product as a good which can qualify as such under the rules of origin of Annex 2. So So it refers us back to Annex 2 of the Protocol on Trading Goods. And Article 7 also says that members will liberalize trade among themselves and remove non-tariff barriers and tariff barriers only on originating product. So clearly, they don't aim at liberalizing the market for goods that are not originating in one of the third parties to the AFCFTA. Likewise, goods shall be eligible only if they originate in any of the third parties in accordance with the rules that have been developed in the annex. So we say there are two main criteria to determine originating status. The first one is wholly obtained product. And Article 5 of Annex 2 actually clearly states that only that the goods that are wholly obtained will be stated to have been originated in one state parties, one of the state parties. So here, this good is only grown, raised, and fully traded as such from the country where it was harvested. So this is the first criteria. If no material from outside the FTA has been used as input, okay? Because under the AFCFTA also, we'll see that when you talk about accumulation, they use the whole territory of the FTA as one customs territory when it comes to accumulation as well. So here, the wholly obtained product under Article 5 are clearly the example of that. Natural resources, live animals, born and raised, including meat, are classified as wholly obtained, therefore as originating product. The example here, gold which has been mined in Ghana and is wholly obtained because it is extracted on Ghanaian soil. So if it's sold as such, then of course the gold originated in Ghana. Likewise, maize harvested in Nigeria is wholly obtained even if the seed were bought from somewhere else, because again, the seed was planted in Ghana, it grew in Ghana, and it was harvested in Ghana. So this good is wholly obtained in Nigeria, sorry. It was wholly obtained in Nigeria. Then, substantial transformation. Substantial transformation is where the matter gets complicated when it comes to rule of origin, because the wholly obtained is easy to satisfy whenever you can show that the product was wholly obtained from your jurisdiction. So now here, there are requirements to determine origin by showing substantial transformation. The first one is specific processes. So you must show to what extent there was a skill that was used to end up getting the product which is being sought to be traded under the AFCFTA. Here, I use the example, or you can see even the manual on the rules of origin, that if a country, let's say, import diamond from another jurisdiction, raw diamond, and now process it, polish the diamond, and now sell it as polished diamond, then this is the process which actually confers origin on the country that has polished this diamond. So this is one of the specific processes that are involved in the manufacturing of a product and which eventually confers originating status to that specific product. And like I said, we mentioned already the change in tariff headings. Here, the example we use already, a computer, a cell phone, which you buy cheap or any part of it, and you end up obtaining a totally different product from what was used as an input. Then, of course, the change of tariff will mean that from one input to another, the output has undergone substantial transformation, and the change of tariff will qualify that as originating product. Here, plastic cap, shower cap, not that I use one of, I don't know that I use plastic shower cap. If you say you buy plastic materials from China, and then of course you end up obtaining, at the end of the day, plastic shower cap. Then the plastic shower cap is not the input you bought from China. Even though the input was taken from China, the end product is the plastic shower cap. And you have value addition. Value addition is expressed in terms of maximum or percentage of non-originating materials which is allowed. In other words, like I said, or we already mentioned that, you may have again, this applies from product to another. So it doesn't apply across the board because products do not require the same amount of input or in terms of work for it to get out as a final product. So here the percentage will differ depending on the technicality, how difficult is it to transform the input into the output. So if you have let's say fiber, cotton fiber, or if you have let's say a car wheel, depending on that, the amount of work that is needed to obtain the final car that is now driving, and the clothes that can be worn is different, right? So you actually need to use different percentage in terms of input for that to come out as originating product. So value addition here will depend on the amount of let's say, labor that is put in that, the amount of X work price, which you and overheads, which I use also in order to manufacture the end product. So value addition, percentage, depending on product, doesn't apply across the board. Do not apply across the board, and are product related. Was it? Okay. So okay. Substantial transformation. Then the third criteria for substantial transformation is accumulation of origin. So we know some other countries, not all countries are at the same level of development. So the rules allow countries to source their input from different jurisdictions. And whenever they do so, they will assign originating status to the country where the last transformation took place, and the last substantial manufacturing and the end product took place. So there are rules to determine how to do that, and this is provided for by an Article 8. So a country can simply use different inputs from several jurisdictions and manufacture a product. And again, depending on how good that good is technically impossible to manufacture, that will determine the amount of input that is used in there will determine whether or not the goods can be conferred originating status. So, however, there are certain processing that are made which would not confer originating status to the end product by simply buying goods from Temu, Amazon, name them, and simply repackaging them in one jurisdiction will not confer originating status to the countries where the packaging took place. Okay. Also, the same with ironing clothes will not confer originating status. Even the simple act of buying live animals and simply the act of slaughtering will not confer originating status to the good has been slaughtered, because this is not any technical processing which will be used as input to the manufacturing of the end product. So how do you prove origin? It's another question, because you have to show to the customs administrations of the importing country that your goods originated in Ghana, Nigeria, Tanzania, right? For you to claim the preferential tariff rate. Because the issue here is for your goods to benefit from the preferential tariff rate which that country said you're going to apply on goods from AFCFTA third parties and not to other countries' goods. Because otherwise, you have to pay the MFN tariff, which applies to the rest of the world. So you have to show that you meet the requirements and that country should apply zero tariff or, I don't know, their rate. That's example of zero could be very important here. So the documents that are required, you have to obtain a certificate of origin, and of course, customs administration will be the ones issuing that. They will have to come to your factory and make sure that what you claim as inputs actually are either wholly obtained or that the transformation that you claim has been undertaken, actually, that this is true, that you actually did this processing. So this is very important, so that you can show to the customs administration of the importing country that your goods actually is made in one of the EFTA state bodies. Apart from the certificate, which is asked from all traders, you also have a declaration of origin. So here, these people don't need a certificate because customs administrations trust them. They are usual exporters of these goods. They simply need to declare that their goods originated in one of the countries. So here, they don't have to obtain a certificate or to show a certificate, but simply to file a declaration of origin. Also, private individuals, because the amount of trade of goods that are being traded about private individuals is so low that you may not have to, you cannot invest a lot of money into trafficking or into trying to game the system. They simply say, well, if you say your goods originating in Ghana and you are in Tanzania selling goods under which value is below $500, yeah, you simply need to declare. Likewise, if you are a traveler with goods which value is below $1,200, you don't need to obtain a certificate. You simply need to declare origin of that product. So this is how you show that your product originated in one of the countries for you to benefit from the tariff rate that applies to goods which the country promised to apply or to impose. So, very important also is that apart from being a trade policy instrument, because again, the preferential tariff rate apply only to originating product. Okay, the rules of origin are not merely trade policy tools. They're also industrial policy tools. Industrial policy tools, I think the EFTA is trying to even develop a protocol on industrial policy soon. But the rules of origin already can be used as an industrial policy mechanism in the sense that they actually encourage producers to use local inputs. And this creates procedures or mechanisms for industrialization within the continent. So if you want your goods to qualify as originating product, you need to source your input within the region. Right? So this also encourages people and can be used as a substitute to import substitution. Okay? Because also, if you want to benefit from that, you simply invest in one of these countries, use the local content for that to meet the requirements of originating status. So it's not only a trade policy instrument, but also an industrial policy instrument as well. And even though we've been talking about trading goods, origin as a concept is also important in the EFTA when it comes to services and even investment, because the rules on services and investment also apply only to service suppliers of a national origin. So the rules are also designed to simply benefit nationals of state parties or those who are there, who are permanent residents of these countries. Just like in investment, the investors are the ones who have the nationalities of state parties of the EFTA. So how do you determine origin is through nationality? In the case of services, the origin can be determined through even not only nationality, but also permanent residence. So it's important that we keep that also in mind when it comes to the concept of origin. And with this, I conclude my discussion. Looking forward to our talk.
Thank you very much. Wonderful. Excellent. As per our tradition, please, we take 3 questions and 3 and 3 and 3. Okay, the first three. 1, 2, 3. Okay, no. I count like this, 1, 2, 3. Yeah, because there is a lead there, so 1, 2, 3. Yeah, so start it. And then you can go and stand next to the lead there.
Thank you very much, Prof, for such a wonderful presentation. I want to know whether the AFCFTA has enjoined member states to put punitive measures for maybe fraudulent exporters, because in any system we'll have people that may want to beat it by maybe making false declaration that, okay, we got this product and this product from within the region, which of course maybe they are getting it from elsewhere out of the AFCFTA. Are there any provisions like that enjoining states to at least have punitive measures if an exporter makes false declaration and later on in the long run it is found out that the things this exporter outlined under the declaration are all false? Are there any punitive measures to at least punish those people?
Next there. They need to come to. No, give him the mic. No. Go on and after it. Yeah, it's working.
Okay. So I have two questions. So the first one is, I was wondering, since the AFTA is primarily for African countries, I know that you said that sometimes with regards to rules of origin, the items may not necessarily be from one country. And so how you explain that usually with something like automobile, you find something from Germany, you'd find something from, let's say, America, and then you'd also find maybe the chassis from maybe locally or something like that. Since we are primarily supposed to be concentrating on African countries, in terms of the classification, when it comes to tariffs, is there some sort of layer to it where maybe they would look at a particular product and if it's more from African regions, perhaps the tariffs would be a little bit lower, but then when we see that there's more things from advanced countries, it's a little bit higher. In terms of the classifications, is that what AFTA does? And then the second question is also for the certificates of origin as well, when you look at where the different items are coming from, when the certificate is given to someone, is it just rounded up as, let's say, the origin coming from, let's say, Tanzania? Or do you see percentages like, okay, maybe 12% Tanzania, 10% European or Germany? So those are the two questions. Thank you.
Okay. We go here, and after that, then you after these three, is going to ask the question.
Okay, thank you. My question is similar to what my colleague just asked the first question, though it's just the context. So my question is, where a product incorporates substantial inputs from outside Africa, but undergoes meaningful transformation within several African state parties, what should be the dominant test under the rules of origin? More to do with the tariff shift, the value addition or substantial transformation, and which approach best advances the agreement's border objective of African industrialization? Thank you.
Thank you for these very challenging question, thought-provoking question. So, whether there is a penalty, you're asking whether or not, what's the variable that prevails, and you're asking about whether or not the certificate of origin, whether you can be manipulated somehow. So, the certificate of origin is issued by customs administration, right? They've conducted their own investigations, or any authority that is authorized. to issue these certificates will have to conduct their own investigation. They will visit, for instance, your plants to make sure that what you claim to be the amount of input actually is the truth. For them to be to give you that certificate, which you cannot use on other products because they are issued on specific products. So it cannot be traded across whatever the variety of goods that you are used to trade in. So they're issued for specific, let's say, transaction. Let's use that word. So there is no penalty, but if you commit customs fraud, the domestic law will apply to you because again there are rules domestically to address customs fraud, right? So it's not AFCFTA per se. This will fall under domestic laws of countries.
Basically trade union, and they will not have short measures probably. So I was trying to know whether they have enjoined state, but since that is now clear from you.
Because the financial penalties will be imposed by the countries you started to defraud.
Yes.
So it's going to be a domestic armed that will catch and penalize or punish your fraud. So when the goods, when the accumulation occurs, you are asking whether or not the change of tariff or the accumulation will apply. So it's when you cannot meet, or these are simply criteria to determine which one will prevail. So certain goods, you can simply use the change of tariff because it's easy to simply obtain an input from one country and manufacture and obtain the output. But sometimes it's very difficult, so you need to source your input from different jurisdictions. In this case, you will show that this is accumulation of origin, not the change of tariff per se. So these are mutually exclusive criteria to determine origin. Yes, please. I'm sorry, I didn't take note of that.
Okay, so one of them, the first question was, since we are primarily concerned with African countries, so when we see, let's say, 2 certificates, or would we be able to tell that, okay, this country used more African, things from Africa here, and this one used a little bit. I know that with some of the industries, we cannot really help ourselves, like automobile, but then there are certain products that, let's say cosmetics, that that some people can get things from Turkey and other places where things are cheaper. And there are those that would use local products. Would you make that distinction and say this is more, they accumulated things more from Africa, and so even if there's supposed to be any tariff, they would be lower. And then since this cosmetic had more things from, let's say, European countries or something, they would have a tariff that is a little bit higher, just to promote more African, production.
Okay. I think my colleague that will come later will address product-specific rule of origin. But to answer your question, well, when countries schedule their commitment, their concessions, they use the harmonized system, right, where they describe the codes that apply to each product. So they may say that the input will not necessarily, they might describe the goods differently depending on what type of ingredients are used to manufacture these products. So it might mean that the same, let's say, eyeliner is not the same as the ones that have been made using, let's say, biological inputs or something like that. So it depends on how that country has scheduled the specific product you are talking about. It doesn't show, the certificate will not show that the input was, it's simply, the certificate of origin will attest to your goods being an originating product based on whether or not it was wholly obtained or whether it was substantially transformed. And to what extent, or that will have to show, that's how you have to show to customers or officials for that to issue you that certificate of origin, for you to be able to trade it, to be able to trade in these goods.
The next 3 questions, 1, 2, 3. So we started. Alex?
So my question is with regard to special economic zones. So in East Africa,
they are treated as outside the customs territory. So just wanted to understand whether the AFCFTA would consider this as a factor, and whether products that are manufactured within a special economic zones are treated to be outside the AFCFTA, and whether it's also just a consideration for giving the certificate of origin.
Well, yeah, this question of special economic zones is one of the developing issue also under the rules of origin, because, oh, sorry.
Hello. Presentation. I decolonization. So, on proof of origin. On the proof of origin. When it came to what do you call it, declaration of origin, I saw you citing all the, after, Constitution citing figures in dollars. We have 47 member countries who have ratified, the after. So if 47 members have ratified, if we don't have a common currency, why as after we will not, agree and choose one country and say that, let's use Nigeria currency, let's use Tanzania currency, and do business in that currency. Why do we still use the dollar? It means that we are not decolonizing ourselves as Africans, and that is my problem. So we should choose, a currency among the 47 member states and do business, with that. Thank you.
Thank you, Professor. I request your indulgence if my question is out of place, but I think looking at the program, I don't see who would be the right person to address it. I think it was Dr. Vela who took us through the core objectives and principles of AFTA yesterday, and one of them is to boost industrialization, and I think it's related to the issue of rules of origin. So I wanted to understand from your expertise, because a lot of the trade imbalance that actually inhibits participation in the AFTA may be a reflection of a limited industrial capacity in the different state parties. Some just don't have the capacity. And that capacity cannot be created without access to adequate energy resources. So AFTA has the ambition of boosting industrialization as one of its general objectives. What specific measures or initiatives does AFTA contemplate or encourage, whether it is through the RECs or at any other level, to help improve our energy infrastructure and also our capacity to generate adequate energy to actually create the industrial capacity for certain economies to actually participate and benefit in this? Otherwise, you can talk all you want. If you don't have the capacity to create industries, you are going to be at the receiving end of this arrangement, and then that would inhibit your interest in playing in that game.
Start with the last question. Yes, I think signing treaties is good, but these need to be implemented practically. And infrastructures are one of the issues. Some of the issues which countries actually are faced with, the challenges to trade using the infrastructure, even the road infrastructure to move goods from one border to another, or even other infrastructure, even the open skies. Coming here, we all have to transit through several cities or several countries before getting to Tanzania. So these are some of the infrastructural challenges which the member state or African countries actually encounter. Now, in regard to electricity and energy questions. Yeah, this is very challenging. I understand that, but I don't have any answer to that. I don't know which measures have been taken by African Union members to encourage that, because not all countries are blessed in the same manner with energy resources, right? So I don't know whether or not there is a requirement for them to share their capacity or not, but this is not yet a given. So this is a reflection which we need to all have around that specific question. Now, coming to the dollars. Well, yes, the currency issue. I don't know what to say about that, because it doesn't depend on us here. Actually, members, they hold their currency dearly. I don't know which one wants to surrender the use of shilling, CDs, or naira, or kwacha. I don't know which country wants to surrender that. This is something that's going to be decided politically by head of state. So yeah, we might simply be using US dollars because this has been the international trade currency for a long time, even though some countries dispute that. They want to use renminbi nowadays. They could have they could have simply designed it in renminbis or in British pounds, depending on the familiarity or affinity with these countries. So the special economic zones, whether goods manufactured, I think your question boils down to whether goods manufactured within special economic zones will be given originating status from the countries that created these zones. So there are different views around that. Among regs, there are certain regs which will recognize goods manufactured in special economic zones as originating product. Others will not. So this is what the FCFTA has had to deal with. So for those who are not familiar with special economic zones, these are zones, areas created within specific countries where investors or where operators actually, let's say, attract investment and ask those who are interested in setting up factories in this zone to manufacture goods without giving them incentives, such as tax incentives or labor intensive incentive. So these zones, now the problem is that these are subsidies, so to speak. And the goods that come out of these zones are actually competing unfairly with other goods that had to pay the taxes outside. So the legal question is now whether or not these goods are comparable. Can you say that the goods that were obtained without paying taxes can be traded under the same terms and conditions as goods that were obtained by a producer that had to pay certain taxes? So this is where the countries have to agree on whether or not to consider these goods manufactured within these zones as equally as originating as those manufactured outside these zones. So yeah, not all regs have the same view around whether or not to confer originating status to SEZ's manufactured good product.
Another round of 3 questions, 3 comments. Okay, Justice.
You don't lose your...
With regards to foreign currency, okay. The FCFTA, in partnership with Afreximbank, launched the PAPS system, which is the Pan-African Payment and Settlement System. I did a paper on that some time ago, and in which exporters could be paid in their local currencies instead of dollars, in order to dollarize the way we have been doing trade. And according to studies, we lose or we spend about 5 billion every year on foreign exchange. You know you have to pay to do that. So the only challenge, one of the challenges we are facing has to do with the control of inflation. We have some countries like Zimbabwe. Do you think someone from Zimbabwe would want to receive payments in Zimbabwe dollars, considering the kind of inflation in Zimbabwe? So these are the challenges. Some exporters may not want to receive payments in that. So that's why the PAPS is not like being received by most states, and not just the states, even exporters may not want that to happen. Yes. Well, so if we are able to control inflation, maybe in that case, most people would want to receive money in their local currencies.
Well, it's just also a follow-up on that interesting line of the dollarizing and paying in US dollars. My brother there speaks of a study that he did. But in my view, I think it's not so much to do on what the AFSTA countries will decide on. Remember the geopolitics. Remember that the British Empire was the last before the US took over. They call it the petrodollar story, which is under threat, as they say, of the war that is going on right now. And guess who's waiting to be the bride to be is the yuan. So most of these countries are actually now associated to China. That's the likely bride to come in rather than the South African rand or whatever. Thank you.
One more, then you can. Please go ahead. Okay, you can.
Please,
go ahead.
All right. I think as regards the certificate of origin, I think what she had asked, like maybe you can look at, it's part of the appendices to the Annex 2. So it can also give you an indication of what is contained therein. And it's a legal document, it's a declaration. So even if you're going to put false information there, then I guess you'll have to face the legislation, I mean the full force of the law. I think as regards, what is it called? SEZs. Article 23 provided for that, the protocol on goods, trade in goods, and it provided then that the ministers would have to make regulations. So indeed there are regulations on how those goods have to be treated. But we all know that SEZs, at least for Kenya, they were used as part of sort of an industrial development, but you are manufacturing for a different market. So you'd find you're manufacturing for a specific market. So the ministers made regulations on how those goods are going to be used. They don't necessarily get automatic, originating status, but there are regulations on how those are going to be treated in as far as the goods end up into the African market under the AfCFTA. Thank you.
Yes, mine is a short one. It's a response to the others. The gentleman who cited Zimbabwe as an example. I just want to put him up to speed. We no longer have the Zimbabwean dollar. We've got what we call the Zim gold, which is actually linked to the gold reserves we have. And currently we've got a basket of many currencies. We're in the multi-currency dispensation. So no fees. We can export or import from Zimbabwe. Thank you.
Thank you. Prof, over to you.
Many of these were comments, right? Don't necessarily need to address them. I think, the PAP system exists where everybody can pay in their own currency. I think we've received assurances that Zimbabwe is not bankrupt, right? So they can actually meet their international payments using their reserves. So yes, you're right that the AfCFTA actually provides for SEZ mechanism, because one of the questions that actually is around is that the goods end up either in a custom territory of one country or they are used as export processing zones. So they are manufactured for export. So this is also very challenging in African countries, and not all of them have the same criteria to determine origin, which is why we still haven't have a final conclusion as to whether or not SEZ products will be conferred originating status.